Kalikumutima and Company Advocates, translating visions into reality.
Estates of deceased are subject to vulnerability.
Olina ettaka oba ekibanja naye kiba kirungi nnyo ekibanja kino okukiwandiisa. Of course, generally having safeguards and risk mitigation of fraud, which is, I think, is the main issue now in the land sector currently today.
The public is not aware about what you're doing. There's a lot of perception out there that most of the fraud comes from the titles office. People are not aware about their rights, and those who are have a lot of fear.
Technology is good, but there's also endless fraud in a way. Before, we used to look at signature challenges, forgeries of signatures, where people are tempted to do handwriting, and you could see that handwriting is not matching. But now with all these apps that are available, I can scan your signature and put it on a document, and your signature is as good as real.
Land is actually the only asset that I know that does not depreciate in value. Estates of deceased are subject to vulnerability.
Kalikumutima and Company Advocates, translating visions into reality.
Good morning, our viewers and listeners. Allow me note quickly that it is a weekend. That is why we are dressed casually, but casually smart. I want to thank our host, the Commissioner Land Registration, Mr. Mugaino, for his time. It is not every weekend that you see a public servant in their office. Thank you so much, sir, for taking off time, especially after Eid. I know many people in your shoes are still in bed resting. So thank you so much. We want to thank you wholeheartedly. To our viewers in the diaspora, I know there's a time difference. So for some of you, it is good afternoon, good evening, and maybe good night. Keep tuned in. This is the continuation of our land series segment. We have the humbling opportunity of interacting with Mr. Mugaino, who also doubles as an advocate. He's an advocate of the courts of judicature. He has a very big CV. Sir, I will not go into your CV. It is very big, but I want to thank you because I have interacted with this office. This is my second decade, and it is the first time I have seen cameras allowed in an office. You have basically brought in the public to interact with you. I usually knock at that door, walk in, and you say, come, and I sit in this very chair during working days. So I want to thank you for allowing the public to come to you. Many are wondering, what is special about you? This man is writing, and thanks to one of your wonderful articles, that is why we're here. Mr. Mugaino authored an article on protection of estates of deceased in Uganda. Protection of their property, to be precise. How do we protect the estate of deceased people in specific regard to their property? Of course, Ministry of Lands has a cardinal role, and I will humbly request the Commissioner, among others, to explain the role of his office. And during the course of the interaction, we'll get to learn and know what you do exactly as far as preserving estates of deceased persons is concerned. You're most welcome, sir. Please take us through the role of this office and also this unique passion that you have about writing. We have not seen very many public servants writing, more so from this ministry. I'm not saying that there are none, but yours seems to be a very unique passion. Over to you, sir.
Thank you so much. Good morning. Thank you for giving us the opportunity to have this podcast. One of the unwritten core role of the Office of Titles, I believe, is knowledge empowerment. And knowledge empowerment means bridging the gap between our clientele and ourselves. And through that bridging of that gap, that we shall be able to mitigate fraud. Because when I believe that when the community is empowered with what they're supposed to do and with the knowledge, then they are able to be also players within the land registration function. So that's the reason why when I got a call from you, despite the fact that it's a public holiday, despite the fact that yesterday was Eid, this is another opportunity to engage with the public, for them to have that knowledge gap lessened, so that you're able to solve most of these problems. And that is the actual reason what writing does. Because apart from that, writing is also able to identify the gaps within our registration systems, the gaps within the law, stimulate debate that shall enable us to have a successful land reform. So that's basically the guiding principle or factors behind that knowledge exchange. Because with knowledge exchange, we're also able to get feedback as government on some of the areas that we are not doing perfectly well and where the public needs to us to improve. So to answer your question, the core role of the Office of Titles, of course, the Office of Titles is maintains the register, which is the registered land and titles in the country. We kindly, the commissioner is supposed to advocate for policy reform, law review, general guidance in the sector, advocate for effective land registration or land documentation. Let me use the word land documentation. What I mean by land documentation, yes, olina ettaka oba ekibanja naye kiba kirungi nnyo ekibanja kino okukiwandiisa. Kati nga wokiwandiisa kugamba oba weerese nti oba nannyiniwo obutadde mu bwino, tekitegeeza nti no oba tekiwandiisiza tekiriiwo. Naye buli woteeka ekintu mu bwino kiba kyanjawulo nnyo nga wekitakola ki nga wekitaba wala nga tekiri mu bwino. Then, of course, generally having safeguards and risk mitigation of fraud, which is, I think, is the main issue now in the land sector currently today. Of course, not directly related to that, but to what I'm going to say about also the ecosystem protection. This is not directly related because there are other agencies, but I think the commissioner also plays a role in trying to ensure and monitor whatever is coming in that does not infringe on the ecosystem. So, and then general registration and deregistration of registrable interest. For example, okuwandiisa, sijja kuyita bwannannyini, okuwandiisa interest oba emigabo mu ttaka ne okujjako emigabo mu ttaka egyo. Kati nga mortgages, okuwandiisa amabanja ga banka, nga abaguze nga tebana kubeera transferringa, like those transfers before purchase, and then ne abo abalowooza nti no balina obwannannyini mu ttaka obutanaba kutegeerebwa. Kati nga abo bamulekwa abakyagoba ku mpapula zaabwe naye nga tebanaba kuzifuna. For example, like beneficiaries of an estate that want to have to protect their interest before they actually are through with the instruments of court that grant them that power.
Wow, thank you. Your office does a lot of work. The public is not aware about what you're doing. There's a lot of perception out there that most of the fraud comes from the titles office. In my opinion, that is not even true. You do so many good, unique things. You have listed so many things that many of us, I may not as an advocate, but I'm sure very many people in the public do not know about. So I want to thank you once again for making time, because people are not aware about their rights. And those who are have a lot of fear. They assume that these offices are barricaded, the public has no access, yet you're here even on a weekend. So we want to thank you for that wholeheartedly. We are going in this discussion to assess whether our laws are efficiently addressing their cardinal duty of protecting or preserving deceased estates, because I believe that is why they were put in place in the first place. Two, land is a very key component of every estate. For the benefit of our viewers, that is why we have the Commissioner Land Registration in his office early in the morning. All these assets sit on land. Land is actually the only asset that I know that does not depreciate in value. Just to summarize for you what the Landed Commissioner has just shared, estates of deceased are subject to vulnerability. They are subject to attack, if I may call it that. The period, and I got this from your article, you authored it, I'm not the one, but I remember you put it so well. The period after death is a very trying time. It is clouded with legal uncertainty. Those were your words. Two, it is clouded with emotional vulnerability that people tend to take advantage of. We have so many people who are opportunistic, third parties, not even connected to these families, that interact with your offices. Of course, at a certain stage, you will tell us how you manage these issues. Then we have distant relatives who may not even belong within the prescribed formula that you allude to. Then, of course, we'll request you to give us examples of the fraudulent dealings that your office has interacted with. I know there are mortgages. The public will want to know, what mechanisms do you have in place? Now, our viewers, we are diving right into the core of our discussion. In your article, Mr. Commissioner, you talked about the beneficiaries caveat. I would like to request you to explain to our viewers what the beneficiary caveat is, what its functions are, what is the role of your office as far as it is concerned. But before you respond to those four, just give us quickly how the landscape is looking like as far as these estates are concerned. How are you able to detect the fraudulent dealings? And give us some examples.
The landscape as far as those estates is concerned is a little bit complicated, just because the players are many, from the Administrator General, the district system of the Administrator General, the COWs, the local councils, and notification of death with the NIRA. There's a lot of bureaucratic systems that are interplay. So, because of a lot of the bureaucratic systems that are interplay, including the obtaining of the grants, both probate and letters of administration, the court system itself, it may take a minimum of maybe 3 to 6 months as early if everything is in place. Now, because of the time period that is involved before these estates come within administration, it's a wide gap through which most of this fraud can be played, and especially by the very family members who are aware about this information, people who are holding titles of the deceased. In most of these fraud cases, the fraudsters are not very far away from the family members. They are within the family systems who know where the deceased instruments were and who are able to do some of these forgeries. So now, at what point does the land registry come in to try to prevent this fraud? Now, the land registry can only come in on notification, because we are not aware when ABCD has become deceased or when the estate should now be under the administration. And who notifies the land office? It should be the very family members who are aware that a close person has become deceased to notify the land office. And of course, when we say a beneficiary's caveat, the law was very strict in trying to protect at the same time who a beneficiary is under the RTA. Of course, it talked about somebody who's mentioned in a will or a trust, or a testament, whereby you make a will and say ABCD property belongs to ABCD, because that's direct evidence that this person left a property. But then the question here was always that what about those people who have died intestate? Now, although the RTA did not go in line to talk about people who have died intestate, that gap has been closed by now the Succession Act. So what role do we play as registers of titles is to have that linkage between the other law to our current law, because the Succession Act puts in place the actual beneficiaries of our properties of a person who has died intestate, how it is governed. For example, when it talks about the 20% shares of the widows, protection of the family property, family home, and ABCD. Now, we use that to extend that extra protection of the beneficiaries by allowing a caveat of a person who has died intestate to also register a beneficiary caveat if you fall within that category, and using the other evidence that's mentioned in the Succession Act after getting confirmation from the Administrator General. Because now we have to rely on the Administrator General, because the intestate procedure falls within the Office of Administrator General. Of course, it's not easy for these intestate estates to go through that process and equally alert our officers, because itself has its own procedures, family meetings and things like that. So in one of the reforms that we have been advocating for is probably on notification of death, having a temporary bar to the deceased estate, an automatic temporary bar to a deceased estate, pending these families going through those formal arrangements. And that would mean, even without computerization, having full integration with NIRA. At the moment, we have integration with NIRA when it comes to identification, during the process of registration and tax payments. But when I talk about the full integration, it would mean that when somebody notifies NIRA a notification of death of a person, that notification should directly interlink with the property register. When that full interlinkage is done, and the law is amended to provide that, so that we get a temporary bar which gives time to these emotionally distressed relatives of the deceased to organize themselves and come up with the terms of the deceased while the estates are protected. And there's a gap that normally is exploited, which the law is silent about. A person signs a transfer instrument before he's deceased, and then registration does not take effect, and then somebody brings the transfer instrument after the person is deceased. At the current time, we're not able to know unless that notification is done that the person was deceased. But also there's a question which we need to answer into the legal debate. That is that transfer instrument is still effective or not effective. For it not to be effective is subjective of the evidence that can be brought. But that's also something that we need to close within the law amendment and law reform.
You actually read my mind, because I was going to quickly ask you, is that instrument effective? Because,
yes.
And you rightly put it that it is dependent on what? On evidence. Because for me, I would argue and say that at law, once a person dies, if they have executed any contracts, they die with them. So similarly, if the registration has not yet been effected and the person has died, then the estate should what? Should come in and take over. You should have the administrator then registered, not going ahead to effect the transfer. But I have seen so many schools of thought say otherwise. They say no, registration is just a formality. Maybe Commissioner, you can advise us. Registration is just a formality. In as much as the person is dead, they signed the transfer form before they died. And like you said, how do we know?
You see, first of all, we do not have a mandatory registration period or lapse. These are some of the things that we are thinking about in law reform. That the moment you have purchased an interest, should there be a mandatory registration of that interest? Because it's a common practice here that people purchase land, do transaction, and then they take their time to effect a registration because of maybe reasons like tax payments, stamp duty, things like that. So should we have a mandatory period under which all effective purchases must be registered? That's also another debate. Now, because we don't have that mandatory period, yes, I may choose not to register my interest, and that's not illegal, and then this other person that I bought from becomes deceased. Does that mean that the instrument that was transacted or that was effected by this other person, should they be nullified? Of course, the answer to that again is again no. No. Because you will find that yes, consideration was paid, consideration was received by this other person. The other person handed over the duplicate certificate of title, handed over the transfer form. So it is a debate. It is a debate that needs to be taken into question. I think your argument, or the argument you're talking about, that when a person is deceased, probably that all instruments signed by that person should not be effective, can only make sense if there's a time period under which it's mandatory.
Yes.
That registration has to be effected maybe within 6 months of somebody purchasing a particular piece of land. Of course, it's not related to this argument, but where this proposal, the other law reform that we are trying to promote, where it came up from is that by advocating for mandatory registration, it is also a fraud mitigation mechanism. To be a fraud mitigation mechanism under which it would help in fighting some of this fraud, because in the other side of the discussion that you are talking about, some of the fraud that you have been experiencing happens whereby we have another piece signing more than one transfer instrument to a person. Of course, the priority rules here come in, but also it has been abused by the RPs where they get multiple certificates of title. A registered proprietor claims that I have lost a certificate of title, swears an affidavit, he counts for identification, he goes through all that process, a case to police, he gets a special, he sells one title to Kalikumutima, he sells another title to Mugaino. So where there is no mandatory registration, it will mean that Kalikumutima may not able to, when he makes a search, may not able to know that Mugaino bought his property 9 months ago, although he has not yet registered it. So relating the two scenarios, I think to be better that the law is is advocated for both, because one will have an adverse effect on the other.
Thank you, Mr. Commissioner. Just to recap for our viewers and listeners, we have two legal regimes that are interacting. We have the land laws, the Registration of Titles Act, the Land Act. This office is actually created by statute. The legal regime is put there to govern land issues in this country, both registered and unregistered. Now we see that legal regime interacting with the succession laws. The Succession Act was amended, and we thank God for that amendment. Like the Commissioner touched, there are some reforms that came into place, and these reforms ensure protection or preservation of estates of deceased from land grabbing. Just to give you that quick recap so that you understand what this discussion is all about. The Commissioner did touch the transition period. Once there is deceased, there is a process. One, you need to apply for a death certificate. That is a notification of death that the Commissioner was alluding to. You need to prove that there was a death. You do not just say someone has died in as much as the body is there. That is very imperative. And this applies both to intestacy and testate succession. If someone has left a will, still there has to be proof of death. If it is intestate, you notify the death, then a file is opened up with the Administrator General. That we'll deal with in our other segment. A file is opened up, they give you a certificate of no objection, you go to court, apply through for a grant. The Commissioner did clearly point out that there's a transition period. Now, that transition period is unfortunately taken advantage of by land grabbers, by fraudsters. The period between notification of death and grant of probate takes best average about 3 months. Best coverage, and it can be longer actually.
It can be longer if you're very fast.
If you're very fast. And I believe this is why the Commissioner is recommending possible reform. Of course, at a later part of our discussion, he will talk about the same reforms. He's recommending that there should be a mandatory protection measure that is embedded in our laws on reform. That once a person has died and there's notification of death, you do not touch their estate. Their estate is automatically preserved by law until legal managers who are either executors or administrators are appointed through due process. That is a very good recommendation because this period is exploited. Now, we are going to go to the issue of beneficiaries caveat. But before we do, please give us the common examples that you've interacted with of fraud arising out of estates. For me, I have seen some fraudulent transfers. These instruments come to you. I've seen some of our clients complaining the banks saying a mortgage was taken out. We say, but why didn't you do the due diligence? Just give us a few common examples you've seen.
Well, of course, when it comes to fraud, you have to be very careful because this is a public engagement. People can pick out those examples and try to use them again. Try to use it again to do other fraud. That's why I've been very careful just to look at a few instances of what happens. But all I can say is that one of the challenges that we are getting with the fraud currently is technology. Technology is good, but there's also NS fraud in a way. I will talk about scanned signatures. Before, we used to look at signature challenges, forgeries of signatures, where people attempted to do handwriting, and you could see that handwriting is not matching. But now with all these apps that are available, I can scan your signature and put it on a document, and your signature is as good as real. Of course, that makes detection difficult. Where a family member steals the title of a deceased, he has access to the deceased bedroom, he gets his passport size photographs, he gets a transfer form, and he inserts a scanned signature.
Well, we all appreciate why the commissioner is guarded. He does not want to arm fraudsters with information, but at least he has given us the basic information that we need to know. Now, let's get into the discussion of the beneficiaries caveat. For the benefit of our viewers, and both in English and Luganda, what is the beneficiaries caveat? What are its functions? What is the role of this office in its registration, and maybe what are the challenges that the office has encountered in dealing with the beneficiaries caveats?
Now, a beneficiaries caveat, like the literal meaning of the word beneficiary. Beneficiary mu Luganda nyinza ogamba nti yenze afunamu mu kufa kw'omugenzi. Kakati beneficiary kitegeeza nti omugenzi bw'afa ebintu bye birina okusikirwa. Kati nze aba omusika w'ebyobugagga by'omufu. So beneficiary is the person who is supposed to benefit. Kati mu Luzungu, person who is supposed to benefit from the estate of the deceased. Kati, how do we know that you're supposed to benefit from the estate of the deceased? There must be evidence that you're a beneficiary. Walina okubeerawo bwino alaga nti yegwe omusika mu bugagga, si obusika mu byekika, n'obusika mu bugagga obw'omuntu oli akoze eki afudde. So the first evidence which is not undisputed is a will. Bwina asooka okulaga ly'eddaame. Omuntu aleka eddaame n'alaga ati mbadde nina amayumba 2 lino lya Kalikumutima. Kati Kalikumutima walaba eddaame eryo ategeera nti nno ni beneficiary wa property eyo. Era Kalikumutima tateeka caveat ku property zonna, alina kuteeka ku property eyo eyiye. So the first evidence is a will. The will will show that property A belongs to Kalikumutima or to Beka Mugaino. Now, the beneficiary will only register a caveat to that property which the will has given him, not on the entire estate, because the will has given this property to a person. The courts have even made it more easier that a beneficiary can even sell this property before it's actually given to him by the administrator. Kubanga already property eberachi ye kati ojja okwejesenga beneficiaries caveat. Which is a beneficiary caveat? They must be attached by evidence. The RTA says a will or a testament, like a trust or something like that. Now, in the whole world, there are 2 countries that have that section of the law, because we had I think similar problems. I think Jamaica and ourselves, which have really advocated and went into, they distinguished along the caveat from a beneficiary caveat. Now, even where the RTA became short, the succession amendments have improved by providing for how intestate properties are shared. Now, on the land restriction side, we have argued, because already my rights to an intestate have been statutorized by the Succession Act. We are extending the beneficiary caveat, the shortfall in the RTA, to the Succession Act by logic. For example, 20% shares of the widow and the protection of the family property. So you are interlinking by logic, and this is where the role of a registrar as an advocate matters. Your general knowledge in the law, not having specific specialization one side of the law. Now, on the other side, when you go to the intestate estates, now the question becomes, what evidence shall we use? Of course, the RTA is silent on this, but I hope in the law reform, this will be integrated and expanded to have that clarity. So now this year we have to use considered reasoning. What goes through an intestate application, a family meeting, showing who the beneficiaries are, which is said by the representative of the administrator general, sub-county chief or something like that, and then you are able to see who. So this is a kind of evidence that we will need to extend this protection.
Wow. Viewers, you heard the man. You know, there are many people out there who think that you just do clerical work. I'm glad you mentioned this is why the office needs what? An advocate. This office does not just do clerical work. This office has thinkers who must interpret the law and apply it. For the benefit of our viewers, the Succession Act was amended in 2022.
Yes.
And it introduced several reforms. Now, the succession laws define the rights of beneficiaries. The law determines the interests. The commissioner did rightly put that there is even a specific what? Formula. You don't just assume things. And our laws complement each other. The succession laws do complement the land laws and vice versa. Now, for the land office, the titles office to act, the succession laws must define clearly who this beneficiary is, what interests they have. He gave examples of the evidence that is looked at by the office. If it is probate, is there a will? Subsequent to that, you have a grant of probate from court. If it is intestate succession, are there letters of administration? The office only acts on evidence. And I'm glad that the office has mechanisms to even verify. The commissioner will touch that, though he said he doesn't want to arm the public with so much. But the office has mechanisms to verify the documents that we are submitting. Now, let us quickly get into the functions of this beneficiary's caveat. I have come, I'm a beneficiary. I have my grant of probate from court or my letters of administration. I have lodged a beneficiary's caveat with you. What are its functions for the benefit of the public?
The functions is that it prevents transactions in this property unless consented to by the actual beneficiary. It notifies the entire world that although this property is still in the names of a deceased, although now this property is in administration or in the names of the estate administrator or the person who has given probate, this property actually is owned by the beneficiary. Although it's not a registered proprietor, it is actually owned by the beneficiary. So if the estate administrator is selling this property, the actual person to buy this property from is the beneficiary. No transaction or interest is supposed to happen on this property unless it has been consented to by the beneficiary. In essence, it notifies you who the unregistered owner is.
Wow, thank you so much, Mr. Commissioner. For our viewers, one notification. The commissioner did state clearly that until you come to the office does not know. The office is not part of the estate. So you're not only notifying the public, but you're also notifying the office. You stated that already clearly. Yes. Two, it helps to protect and preserve the estate. And this is very important. The succession laws that I alluded to earlier that provide the formula that the commission attached also talk about the principal residence. In your article, you came out profoundly on the principal residence. We have so many widows, for example. I'm dealing with a case somewhere, I will not mention where a caretaker decided to grab 30 acres of land, registered land, 30 acres. And this was actually a principal what? A principal residence. But fortunately, the widow had lodged a caveat, a beneficiary's caveat, together with two of her children. So they were not, I'm giving a live classical example here. The caretaker and the other fraudsters tried to maneuver to transfer the property. They could not because of the beneficiary's caveat that had been lodged. So briefly, just touch the issue of principal residence for the benefit of our viewers. Not many of them have read your article like I did. They need to appreciate the spirit of some of these issues. I'm sure there's a reason why you emphasized principal residence in your what?
In my article.
In your article, maybe you are thinking about things like matrimonial home and what. Please tell us.
Of course, principal residence, we are talking about the home of the deceased. And I think the law reformers of the Succession Act reflected in, the actual problem that happens in society, where a person becomes deceased, the family homes are sold by the administrators, the family has nowhere to stay, they have no difference, and then the widows and the children and the minors get affected. So the family residences are not supposed to be sold. Maybe if the exceptional circumstances guaranteed for by court, where it is put beyond court that is the best interest of the estate of the children, but not supposed to be sold. So by having that extended protection to the family residences, it means that even where the children are minors, even where the widow or widowers are still in existence, still they have a sense of belonging, or where the family can sit, reflect, they have shelter, and have their lives move on. So that was the essence behind that protection. And now on our side, we are by practice extending that protection to that family residence. But the question again becomes, how do we know that this is a family residence? Now that is where the other arm of government helps with that notification. That during our process of trying to get a letter of invitation for this family, we identified ABCD in the estate, and this is a family residence, a family that needs to get that extra protection.
Thank you so much, Mr. Commissioner. This, in your article, you did state that the beneficiary's caveat has a non-lapsing feature or element. Maybe I will ask quickly, what is the difference between a beneficiary's caveat and an ordinary caveat? Because I believe when you respond to that, you will touch the issue of non-lapsing. Should we assume that it is permanent because it doesn't lapse? That will take me to another question, but if you could kindly quickly respond to that.
An ordinary caveat, lapsing means that when somebody applies for the removal of a caveat, it automatically be removed after 60 days, unless you go to court to get a court injunction why it's not to be removed. And what's the logic behind that? The land register was not meant to be a register of encumbrances. It's where people just come with unasserted claims and encumber the register. That's why there has to be some kind of moderation. So if you believe that you have an interest in land, registration of a caveat does not mean that that interest has been settled. You are supposed to go to a court of law and prove that you have an interest in that particular piece of land. That's why a caveat has to be lapsed. Now, what does it mean for a beneficiary caveat not lapsing? It means that a caveat cannot be lapsed automatically under 60 days because already there is evidence that you are a beneficiary to this estate. So it's speculative. That's why we talked about the will and ABCD.
Yes.
So that's what we mean that it's of non-lapsing nature. At the same time, the register is not supposed to have property that's not administered unilaterally in infinity. The role of the administrator of an estate or a grantee of letters of probate is to ensure that the estate is administered. So if a property belongs to the beneficiary, to ensure that property is transferred into that beneficiary. And when that transfer is done, so you cease to be a beneficiary of that estate, become a registered proprietor. And that's where the succession amendments made an imperative gesture of bringing in expiry of these letters, so that efficiency in that sector was upgraded, because the inefficiency through prolonged estate administration 5-7 years was part of the fraud that was being impacted by some of these administrators. So that inefficiency to the long estate administration was had its own issues. So the question now that you have asked, it does not lapse because already it's backed up by evidence. But it's also supposed to be sustained because estates have to be administered. That's why in my article I said a beneficiary caveat does not stop an estate from being administered. Because if I'm the administrator and you're a beneficiary of maybe 40 acres of land, which the will has given to 5 beneficiaries, I have to sign instrument of subdivision, instruments of transfer, to enable me give the estate back to the actual owner. So, which was another question that how are they removed from the register? Of course, this is where the knowledge of the commissioner comes in play. Yes, there's a beneficiary caveat. Has the estate been administered? Yes. Or the administrator wants to administer the estate. He has brought an inventory. but there's a caveat which only the commissioner can remove to allow the administrator to administer the estate. There's also another interesting argument here, that the moment an estate comes under administration, it means it has come under the supervision of court. Are we clear?
Yeah.
So as a beneficiary, if I have issues that estate, should I come to the commissioner or I should go to court? My thinking that you should go to court, because already the court, an inventory has been filed by the administrator. You know, you file, even the list of the beneficiaries are filed in court at the time when the estate is going to be administered. So issue to do with that estate now becomes within the ambit of court. So the narrow line, to what extent should the administrative caveat stop an administrator from administering? And for me the answer is simple. Court takes precedent over that.
Yeah. Thank you so much, Commissioner.
Yes.
Uganda. Sorry, we have two sets of viewers and listeners.
Kakati eno caveat ya beneficiary yaba ku muntu alina obusika bw'obugagga mu property eyo mu estate yonna yonna kyobola muno tukireeseemu nti wabeerawo eddaame erigamba nti ettaka lino lya gundi kati njagiteeka ku ttaka eryo eddaame erikoze eki erimpadde naye kiba kitegeeza kiti teri kiba kitegeeza nti omuntu naina ayagala okolagana n'ettaka eryo okuligula oba okukola ki aba ategeezeddwa nti ettaka eryo lya gundi naye okuteekako caveat eyo kyokka kyekitagaana administrator ku administeringa ki estate waka administrator aba alina okukwata ettaka eryo alikuwe oba olibanga mbadde muligaba n'abantu bangi aba alina okulisalaasalamu mwena abakole ki abawe obanga olina obutakkanya bonna mu estate eyo ku saawa eyo already estate eyo eba eri under court supervision kati oba olina ogenda mu kooti n'otegeeza kooti tize sina obutakkanya bwe zitalinamu n'omuntu kooti gwe yawadde ki ebbaluwa ejja kwazimisenga estate eyo.
Okay, thank you so much, Mr. Commissioner. Again, to summarize for our viewers and listeners, a beneficiary's caveat is unique. That is why I requested him to distinguish between that caveat and an ordinary caveat. An ordinary caveat can be lapsed. You make an application to the Office of Titles, and after 60 days, it is lapsed. Of course, if you want to stop the same, the commissioner did guide that you go to court and get an order. Unfortunately, many people abuse these caveats. The commission, I'm sure, interfaces with that every day. A caveat is an interim relief, an interim measure. This office facilitates the economy, like the commissioner rightly put. It facilitates what? Trade. So any unnecessary impediments are not tolerated here. Now, a beneficiary's caveat does not just lapse like that. For it to lapse or be removed, one, the caveator can actually just come and remove it. To court, by way of an order, which includes letters of administration, once the process has been finalized by of inventory, can direct that the caveat is removed. I believe this comes a long way in preserving and protecting estates. So for all our viewers out there who have estate, who are beneficiaries in estates, please take note of this. You can reach the Office of Titles, make your application for a beneficiary's caveat, submit it but with proof. Your application should be attached with a statutory declaration. You attach your grant of probate or letters of administration, because the office is not part of your estate. You need to arm it with as much evidence as possible. I will request at a certain stage for the commissioner to talk about the administrative roles. I'm sure one of the issues he will touch is section 149, where you require for more information. Now, if you do not give the office enough information, the commissioner has the mandate to require you to provide this information. What happens, Mr. Commissioner? You have taken us through what a beneficiary's caveat is, You have also stated that it can be removed. It is not permanent, but I'm sure there's a strict what? Criteria. You did tell us that beneficiaries caveat does not mean that the estate should not be what?
Administered.
Yes, so it has to be administered. That would mean that if this caveat is an impediment to that, it will be removed by what?
By the commissioner to allow administration.
Very good. If it is unjustified, if the commissioner feels it is unjustified or a court, they can remove. You have touched the bit of removal. Let us talk about abuse. Abuse. In your article, you give us a remedy. Because like I said, caveats are abused. Not just ordinary caveats, but also beneficiaries caveats. Please tell us, how are they abused? I know you don't want to arm the public with so much. And two, what remedies are there? Many people don't know about their rights. They don't know that there are remedies in the law. You're the custodian. Please talk to the viewers.
Of course, the abuse is an interplay between the public and the land registration function, where you find the register registering a caveat as a beneficiary when it does not meet the required test. Why? For people who want to clog the bachelor property for selfish reasons, one or the other. And of course, the law allows the commissioner to request for further and better particulars. Yes, you find that maybe you have registered the caveat as a beneficiary, the estate complains, and then we go through the documentation and there's no evidence for that. Of course, the first remedy would be to request you to come for a meeting and provide better particulars. Maybe if there's one or two documents that were not attached to your affidavits, so that can be corrected, and the other side that has petitioned can see and answer the question that yes, you're a beneficiary or not. Now, if that does not work, then we have to now to assume it as a registration in error. So we'll have to go through section 91 for you to come as a registration in error, for you to come up and give us that particular evidence that you're a beneficiary or not, or other, if you're not able to comply to that, then we are able to deregister you. Of course, the law also allows a person who has been affected by frivolous caveat registration to apply for damages. I've not seen this in practice being done. And to really prevent this abuse, I think it's an area whereby probably we need to put also some more direct punitive arrangements. I have seen, I think under the Cap and Registrations Act, I think I've seen some damages that are directly given out by, I think, the Registrar General. Under that, I think it may be imperative that probably also we have this debate so that some damages can be given directly to be made too easy for compensation to be given for people who abuse some of these processes without going through the longer litigative journey of the courts. Yes, there have been abuses, but that's one of the remedies that we do to try to safeguard those abuses.
Thank you so much, sir. Again, allow me to summarize for our viewers and listeners. A caveat is not a magic wand, whether ordinary or beneficiary. Two, it must be backed up by evidence. And it is susceptible to abuse. And like the commissioner pointed out, people indeed do abuse these caveats. This office facilitates trade, supports the economy. So, if you do not have the required evidence, you will not be entertained here. And if you are, there is further redress that can be sought against you. In our Registration of Titles Act, Section 126, you can apply to court for damages. Like the commissioner said, and I agree with him, it is not common for people to do this. Maybe it's because they are not aware about it. And I thank you and Kalikumutima and company advocates and our other partners, Twin Shots, for sensitizing the masses. People need to know that abuse is not condoned. If you abuse process, you will pay the price. If you want to avoid that, make your application, have the evidence that is necessary. Fortunately, the law does allow the Office of Titles under Section 149 of the Registration of Titles Act. The commissioner can require for additional information, and if it is requested of you, please provide it, because if you do not provide it again, there will be a challenge. There will be a challenge with that. Number 3, customary land. In your opinion, Mr. Commissioner, does the current regime apply to customary land? Of course, there are Ugandans out there who don't even know that customary land is titled. There was a debate somewhere, and they seemed to be discussing hierarchy of tenure, whether customary title is important. I didn't participate very actively in the debate. It was an interesting one. In your opinion, do these succession laws apply to customary land, especially the one that is registered, but both registered and unregistered?
Yes, of course, where a customary tenure has been registered, the principles of registration apply, like the way we have where we have discussed the registered title. The difference is that these certificates are under a recorder, but the principles of registration are the same. And that is why in one of the amendments that we are talking about is that the certificate of customary registration, the register, yes, can be managed by the recorder, but should come under the commissioner by law for purposes of advocating the general policy guidelines on registration. Because when you go on the regulations, they can subdivide and do everything. But remember, these recorders are not lawyers. So that register has to come directly under the Commissioner Land Registration to safeguard the problems that will come with it. Now we are not seeing problems because few registrations have been done there, but we have to safeguard that. Now, maybe the important thing to talk about is the unregistered land. This is not, there's no customary certificate, there's no FRV, there's no minor title. Of course, the succession amendment law and the possession principles apply even where land is unregistered. But the question here becomes where the people who are applying these principles on unregistered land, where there's enough information to our local administrative systems. That is the first line areas of interventions. The RDCs, local councils, and ABCD. And this is where advocacy has to be done by the Administrator General. And NGOs and we generally as government as a whole, so that this information is disseminated to other administrative arms. Now again, innovatively, you can stop land from coming under the RTA. I think it used to be Section 20, unregistered land. So innovatively, a beneficiary, if he knows that land that is going to be registered under the RTA, where is the beneficiary, he can, under that section, register a caveat. Although that section is not for a beneficiary, but it gives some leeway to enable him have some line protection, as probably is settling out this dispute or something like that. So innovatively, yes, you can use that to act on that.
Thank you so much, Mr. Commissioner. So the Constitution of the Republic of Uganda and the land laws create different forms of tenure. One of them is customary. And some interests are registered. They are customary certificates of title. And we have unregistered interests. The Commissioner did rightly put that the succession laws also apply to unregistered interests. We have had so many scenarios where applications are made arising out of customary land for titling. And I'm glad you did mention that there is a remedy, because some people thought, now how do I lodge a caveat? Under Section 20, like the Commissioner rightly put, you can lodge a caveat to preserve and protect your interest as a beneficiary. Subsequently, of course, the title will be what? Created. So you lodge the caveat and seek further what? Redress. Like we said, a caveat is not a magic wand, and it is not purposed to stop administration of estates. Mr. Commissioner, I know you're a busy man. we need to conclude this segment.
Thank you.
I wish it could go on and on. As we conclude, I want to thank you wholeheartedly for this article. It has been an eye-opener. Just a few parting shots from you. A few key points that you want to emphasize to the public, to your viewers, to your listeners for their take home. Some recommendations, and please touch law reform too. Because the law is ever evolving. Well, I don't know how fast it evolves in Uganda, but the law is designed to what? To evolve. A few parting shots from you, then I'll conclude the segment.
Thank you. We are committed to helping the public, to mitigating the risks that are associated with land registration. And that's why we're advocating for some of these reforms, like the mandatory time bars or notification of death. And internally, we are thinking of some of the, bringing some of the policies that we think can help also to identify some of these gaps. We used to have a problem with land for investors. And then we came up with a one-stop center, the URSB, where we have officers in URSB, where searches are being done in record time, and we don't hear any complaints with that anymore. And I've been grappling with the question here, of something that I've put on paper, subject to my supervisors approving it. Should there be a one-stop center with the Administrator General, NIRA, and lands, so that on notifications of death, there's automatic trigger to all these other players on the land register that this property belongs to a deceased person, as a way of curbing some of these activities. It has worked in other sectors. Probably it may also work in this other sector. So one of the most impactful areas of intervention, with no doubt, would be the mandatory packaging of death notification to the land register, either digitally or through such one-stop centers. That will be able to slow down, because the purpose would be that the notification of death, there should be a temporary slowdown on registration activities on these properties to allow standing to come into place. I think that's one of the closing gaps that will be very effective in that. And of course, we have talked about more than once the temporary halt, which may need to be done through amendment of the law. And we have also talked about the cleanup of the register. Now we have to look at the other side. You can't have these caveats in perpetuity. The virtual cleanup, like automatic lapsing where the estates have been administered. Just like what we did with the mortgages. Under the mortgages, there's the incumbents are not there in perpetuity. There's that automatic lapsing, where the commission has given power to clean up the register. We have been cleaning up the register of mortgages that are 80 years old, 60 years old. You cannot stress both the mortgagees and the mortgagors. So the law also has to have it's either way, both. All this to lead to the efficiency and effectiveness of the land registration system. So we hope that first of all, we are very happy with the law reform that came under the Succession Amendment Act. So this should also be integrated in the law reform that will come under the RTA, probably also further improved. And then also with the policy intervention, things that we have talked about, that integration between the three stakeholders, both digitally and also probably through a kind of improving our coordination on the same.
Thank you so much, Mr. Commissioner. Just to summarize for our viewers, the Commissioner Land Registration is the gate man. And unfortunately, the Office of Titles is a battlefield. We have been talking about protection of estates of deceased against fraud, against land grabbing. The Commissioner was kind enough to take off time and run us through his very insightful article. Preservation and protection of these estates can only happen where there is integration, where different stakeholders are working together. We have seen two legal regimes at play, the land laws and the succession laws. The succession laws define the rights of beneficiaries, determine or help determine the interests of beneficiaries. When you come to the titles office, come prepared. The titles office is not part of the estate. You must come with the right information. Of course, the law does allow the Office of Titles to require you to provide additional information to support your claims. We are glad that the law does provide for a beneficiary's caveat. So for all of you having challenges, the remedies are there. You just need to look for the right professionals and approach the office. A beneficiary's caveat does not lapse ordinarily like an ordinary caveat would. However, it is also not permanent, and it is not purposed to be a bar to administration of the estate. It can be removed by the caveator, it can be removed by court, it can be removed by the Office of Commissioner. If the Commissioner Land Registration feels that this caveat was unjustified, or it is purposed to be an impediment to proper administration of the estate, it will be removed. There is a strict criteria both for administrative intervention and judicial intervention. The Commissioner has pointed out to us that these laws also apply to customary land, whether registered or unregistered. And this is especially to our viewers in the diaspora. The succession laws were amended in 2022. The grants are not given to you in perpetuity permanently. These estates now have to be administered within a particular period of time. To be precise, not more than 2 years. If there is going to be an extension, it is with the permission of court. Many of you have been holding on to letters of administration. You need to get in touch with the right professionals back home, apply for extension or renewal of these grants. Now, over time, it has been noted in practice that the caveats are abused, but there is also a remedy within the law. Under Section 126 of the Registration of Titles Act, if you abuse this process, if you purport to be a beneficiary whereas not, a claim can be brought against you in the courts of law for damages. Whereas it has not been happening, with this sensitization and more people are going to wake up, we need to be alive to the realities of the day, alive to our rights. That is why the Office of the Commissioner Titles and Kalikumutima and Company Advocates are pushing to fill the information gap. In our next segment with the Commissioner Land Registration, we shall be talking about special certificates of title. We shall be talking about, in a subsequent segment also, preservation and protection of the system. I want to thank you so much, Mr. Baker Mugaino, Commissioner Land Registration, for your time.
Yes.
And allow us classify you as a partner in this cause.
Thank you.
Because you have been our host.
Yes.
I want to thank Kalikumutima and Company Advocates for making this possible. We also want to thank Twine Shots, my brother Gilbert, that is covering this. For all our viewers and listeners, I hope you've benefited from this segment. It is not every day that we get an opportunity to walk into a public office over the weekend. So thank you so much for your kindness and humility, sir.
Thank you, sir.
And we appeal to other public servants to borrow a leaf. It is clear that the Office of Titles is not just clerical. Yes. There is a lot, it is loaded with information.
Yes.
I wish we could get it all today.
Yes.
Unfortunately, we can't. But we thank you for sensitizing the masses. We thank you for writing. And now we thank you for accepting this series. Thank you so much. Have a very nice weekend. Our viewers and listeners, wherever you are, a nice weekend to you. We thank you for God and my country.
For God and my country. Thank you. Thank you, gentlemen.
Kalikumutima and Company Advocates, translating visions into reality.